Courts, and you can get in touch with us on 22422, which is our SMS line. And I want to start by introducing our panel to you for two topics this evening. Judy Thongori is a prominent family lawyer, and she'll be speaking to us tonight on matters relating to the decision on matrimonial property that the High Court issued this week. And later on, we'll be joined by, I should begin with Mercy Wanjao, who's the acting legal director for the Communications Authority. Next to her is Edward Kisiangani, our resident political analyst. To my left is city lawyer Steve Ogola, and next to him is the elephant in the room, Patrick Gadara, curator of the Elephant blog. He is our cartoonist and regular contributor on the show, and you're all welcome to the program. Judy, let me begin with you. This week, the High Court ruled that a provision in the Matrimonial Property Act that requires family property to be shared according to each spouse's contribution is constitutional. The judge ruled that there was no basis to claim that the section discriminates against women, as a women lawyers body, FIDA, had put before the court. Having said that, where does that leave us in law? Has anything changed?
No, nothing has changed, Anne. What happened is that FIDA went to court seeking to increase the rights available to spouses. At present, and since the end of 2013, we have the Matrimonial Property Act that provides that contribution could be financial or non-financial. Non-financial contribution includes childcare, companionship, domestic work, working in a family company, and just about everything that you can think about in support of a family. But it left the discretion to the court to determine what percentage would be put on either the financial or non-financial contribution. So FIDA Kenya went to court seeking to have the percentage settled, that it would be 50-50 in respect of matrimonial property, irrespective of the contribution. That is a case that was lost.
Okay. And does this decision, as some have opined, discriminate against women in any way in a country where the role of homemaker really isn't valued? I
think the persons who discriminate against women are us people, because we do not value our families as we should. If we considered that our families are the most important, by the way, shall I say, Article 45 of the Constitution says the family is a fundamental unit of society and the basis of social order. Mm-hmm. If we practiced that, then it would mean that whether a person goes out to get bread because it's necessary to do so, or a person stays home to take care of the family, their contribution is equal to the family. So unfortunately we discriminate, and I guess you can say by extension that's what happened yesterday. But I was saying, irrespective of what the High Court finds, this nation needs to start having a very serious dialogue. Only yesterday, the Swedish embassy celebrated dads, Kenyan dads and Swedish dads. And what they were trying to bring to the fore is the importance of having fathers participate in children's lives, especially at the very formative stage. I was shocked to learn that in Sweden, after the birth of a baby, they don't call it maternity leave. They call it parental leave. And a family is entitled to 480 days in total. Wow. The first 90 are distributed equally to the husband or to the father and the mother. The others, they may share as they wish. The more equally they share, the more bonuses you get. And by the way, that leave is paid. What am I trying to say? Such a society recognizes the fundamentality of the family. You know, Anne, even what you're going to be talking about later, cyber crimes, about all the things we talk about in this country. Right. Sometimes we forget to ask ourselves, why are we where we are? Why are we trying to correct what ought to have been corrected at the very formative stage of a person, and that is a family. So I say the nation does need to have a dialogue on how important bringing up a family, having both parents present and having them participate is to the future of this nation.
Right. It's a values issue, I mean, that we keep talking about. And you've rightly said, I mean, when we talk politics or anything else,
Yes.
it really boils down to the family, because
Indeed.
even our politicians are members of families, aren't they?
Indeed.
I want to just return to our topic, and you talked about spousal contribution, and in fact, and the judge did make reference to that,
Yes.
you know, the
Yes.
court still provides for this to be assessed. So if you would define that for us, and the parameters that are used by the court when, you know, determining what one's contribution has been.
Okay, the discretion has been with the judge, so to speak. But allow me in a minute to just give you a bit of history so that we appreciate this. Until 2013, we didn't have a local act on matrimonial property, important as it is. We borrowed from an 1882 English Act. In 2000 up to 2007, it was quite accepted that contribution would be financial and non-financial. In 2007, the Court of Appeal decided the famous Isharia case and determined that contribution had to be financial. And so that if you didn't show 50% of financial contribution, you didn't get 50% of the property. At that time, we became very busy having our own local legislation. And that's the one that saw the light of day in 2013, at the end of 2013. And that's the one that now provides for non-financial and financial contribution. Now, the judges are left with the discretion of determining how much to apportion to each person's contribution. But I can tell you that in most of the cases that have been determined in the year since the beginning of 2014, because the Act became law at the end of 2013, we are seeing more of a 50-50 contribution. Because even for the person who stays home, the courts have begun to recognize what I was just saying, the need for the family to be supported in the manner that they are supported, okay? And even many of the people who stay home, you probably find an element in which they also bring in the bread, you know, if you like.
Yeah.
So I think we are moving to a point where even if this case does not succeed on appeal, I'm almost certain that this nation going the way it is going to a point where it's going to say it is 50-50 as long as you show that you supported the family.
All right. So, and to my broader panel, anyone wants to make comment on that? Steve, you're looking at me like I should not look at you, and I am.
My only comment is to self-advise. You know, my learned senior is a thoroughbred family law practitioner.
Yes.
And once she speaks definitively on these matters, and therefore mine is just to endorse and to associate myself with those able comments that she has articulated.
Running for office anytime soon? Okay, Prof. What do you think?
Two things. I think the distinguished lawyer has put it rightly, that we are going to reach a point where there will be a bigger conversation on how best this can be done. We don't need to create an acrimony. And I think the law will evolve, and with the new challenges that are coming ahead, we are likely to have such a kind of thing, and maybe there will be a better ruling than the one we have had, because there are so many underlying issues which we need to think that might have been overlooked in the ruling. But I just want to point out with a lot of humility to the distinguished lawyer that in Sweden, the example she has given, the reason why there's a huge leave for spouses is in fact for the last almost 40 years. Sweden and most of the Nordic countries have had a problem of population, and in fact, people in the Nordic countries, people are encouraged to have children, because there has been, interestingly across the world, growth in the population, but there has not been growth in the population in the Nordic countries the way they want it to be. So therefore, guys who don't get married are overtaxed for not doing that. So that is the reason why Sweden is like that. And unlike in Kenya, where we want to control the number of children we have because there is a population explosion, Sweden is the contrary. So our challenge in Kenya is different from the one that you get in the Nordic countries. That is the only thing that I would point out. But the rest of the stuff, Excellent.
Anyone else want to comment?
Well, what I would say is, without speaking to the law itself, I mean, I fully agree that as a society we need to make certain decisions. And I think that valuing the contribution of women, and it's not just women, there's also stay-at-home dads who would be affected by this. I think we need to really put up and heighten our appreciation for what that constitutes and the contribution that gives. The second thing I would say is we've got to go beyond just married couples. I know this is a law about our marital property, but also to start to think about the burdens we impose on single-parent families. You know, we have situations where girls are fired from work, you know, when they get pregnant, you know, they lose their job. You know, and so these are sort of things that really we need to start seeking legal remedies and providing legal protections for people. I think, again, going beyond that, to start thinking about how we deal with reproductive rights. You know, another very big issue, things like abortion, etc., which keep killing women all the time. I think the last time I read it was about 30,000 that we lose. You know, so it's serious. It's a serious thing. Our laws right now, as they are, especially on the abortion front, really do hurt more than they help. So I think we really need to. It's a conversation that needs to come up and be discussed.
All right, Judith Ongori, thank you for your time. She is a prominent family lawyer.